The court is now in session in the case of Life Grief Watch International versus Republic of Kando. The presiding judge in this hearing is Lady Justice Nancy Baraza, sitting alongside Justice Olaninka and Justice Olayinka.
Madam President, Your Excellencies, may it please the court, I appear as first agent for the applicant, Life Givers Watch International. My name's for the record, Merapelo Speakman, Merapelo. I'm here appearing with me as second agent for the applicant, Kotla Timuluko, KGOLTA. I will be addressing this court on the preliminary issues of jurisdiction and admissibility, as well as the first substantive issue. My co-counsel will then deal with the second substantive issue and the relief that we seek from this court. In making our submissions, I will address this court in 15 minutes. My co-counsel will then deal with his issues in 13 minutes, and we humbly reserve 2 minutes for rebuttals. Thank you.
Good morning. My name is Honorable Justice Retired Dr. Nancy Baraza, presiding. The parties appearing, do you affirm that you will abide by the rules of this moot court and that you will not seek assistance from any external sources, including your coaches, during this oral pleading?
Yes, on behalf of the applicant, we do affirm.
On behalf of the respondents, we do acknowledge.
And you remember that failure to comply with these rules or seeking assistance from outside sources, including coaches, may result in the court recommending your disqualification from the competition.
Yes.
Yes.
Your appearances, please.
May it please the court, I confirm my appearance as first agent for the applicant. My name's for the record, Merapelo Speakman. I'm here with my co-counsel as second agent, Kotla Timolo, and we appear on behalf of the applicant.
All right.
Greetings, members of the bench. My name is Kadamba Naomi, appearing as the lead counsel for the respondent in this case, the Republic of Nkando. Alongside me is the second agent, Anthony Rungu Macau.
Okay. Each team has 30 minutes. And before we start, we would like to know how you want to spend those 30 minutes for each team.
Your Excellencies, I will address this court on the preliminary issues of jurisdiction and admissibility, as well as the first substantive issue in 15 minutes. My co-counsel will then deal with the second substantive issue and the relief that we seek in 13 minutes, and reserve 2 minutes for rebuttals.
Right.
Thank you.
Your Excellencies, lead counsel will take the first 15 minutes to guide this court through the respondent's standing in relation to the preliminary issues, as well as the merits of the first and second issues. The second counsel will use 13 minutes to deliberate on our standing in relation to the third and fourth issues. We seek to reserve 2 minutes for such rebuttals. Thank you.
Your Excellencies, may it please the court. At this moment, or this current juncture, we are at a critical standpoint where the emerging issues of commercial surrogacy in Africa are at a critical standpoint, and the human rights of both surrogate mothers and children are at peril. We ask this court, in light of this, not to impose or to grant any new rights upon the applicant state, or to impose any new obligations upon the respondent state, but to guarantee and affirm the rights that have already been guaranteed in the African Charter and other human rights instruments that the respondent state has ratified. That being said, Your Excellencies, I will demonstrate to this court that this court has jurisdiction to entertain this matter, that the application brought before this honorable court is admissible, and that the respondent state has failed in its obligations to protect, fulfill, and respect the rights of surrogate D in regard to the application or the enactment of Article 55 Sub-Rule 3A and 55 Sub-Rule 6 of the Surrogacy Act of 2017, and the subsequent court's application of these provisions in surrogate D's case. That being said, Your Excellencies, I will begin on the issue of jurisdiction. With regard to jurisdiction, I refer to the case of Jebra Kambole versus Tanzania, decided in 2020, wherein the court held that according to its rules, it must conduct a preliminary examination of its jurisdiction, and it must satisfy itself that it has personal jurisdiction, temporal jurisdiction, territorial jurisdiction, and material jurisdiction. For purposes of time, Your Excellencies, I will deal with the issue of personal jurisdiction, which is in contention in the issues. I refer to Article 5, Sub-Rule 3 of the Court's Protocol, which provides that a non-governmental organization that enjoys observer status with the African Commission has direct access to this court, wherein the respondent state in which a matter is brought against it has made an optional declaration in terms of Article 34, Sub-Rule 6 of the Court's Protocol. The issue here is not whether they have made a declaration, because as the facts show, in 2018, they made this optional declaration in terms of Article 34.6. What is in contention in this issue is whether or not the subsequent withdrawal that occurred on the 20th of February 2024 divested this court of its personal jurisdiction despite the matter pending before this court. As the applicant, we answer in the negative. We place reliance in the case of Ingabire Victoria Umuhuza versus the Republic of Rwanda, wherein it was held that though a respondent state has the ability to exercise its sovereignty and withdraw a declaration due to its unilateral character, such character is the discretionary character of such unilateral statement or withdrawal is not absolute. This is particularly so where a declaration versus third parties must be given, and we still place reliance on the Ingabire case, wherein it was held that, or they drew inspiration from Article 56, Sub-Rule 2 of the Vienna Convention on the Law of Treaties, and they held that a prior notice of 12 months is important to avoid or prevent the abrupt suspension of human rights. It also espouses the principle of non-retroactivity, which basically or essentially means new rules apply to to future situations only. In this case, Your Excellency, the matter is pending before this court, and so the principle of non-retroactivity applies, and therefore the withdrawal of the respondent state's optional declaration does not divest this court of the personal jurisdiction. That being said, Your Excellency, as that was the only attribute of jurisdiction that was in contention, may I move into the issue of admissibility? Thank you. With regard to admissibility, Your Excellencies, Article 6, Subrule 2 of the Court's Protocol mandates this court to conduct an examination of whether or not an application that is brought before the court is admissible. And the requirements that must be satisfied are enumerated in Article 56 of the African Charter. Particularly in this matter, we are dealing with the requirement of exhaustion of local remedies as provided for by Article 56, Subrule 5 of the African Charter, as read with Rule 50 of the Court's rules. Your Excellencies, the principle with regard to exhaustion of local remedies is that before an applicant may bring a matter before the African court, it must have exhausted all local remedies in the local courts, provided that such local remedies are not unduly prolonged. Further still, it is provided that these local remedies must be available, sufficient, and effective, as was espoused in the case of Jawara versus the Gambia, as well as Ajavon versus Benin, which was decided in 2020. Your Excellencies, if these local remedies are unavailable, ineffective, and insufficient, then the requirement to exhaust local remedies should not be required or should be waived. It is our submission in the present case, Your Excellencies, that the exhaustion of local remedies in the current matter are unavailable and unduly prolonged. Unavailability refers to them being pursued. Availability means them being pursued without any impediment. And unduly prolonged in the case of the beneficiaries of Nobet Zongo versus the Republic of Burkina Faso, it was held that unduly prolonged is determined on a case-by-case basis, and it depends on the factors surrounding the matters. In the present case, Your Excellencies, the matter has been expedited without a doubt, and the matter will be heard on the 12th of March 2025. That is not in contention, as the respondent made an attempt to expedite the hearing of LWI's application. However, what is in contention here is the duration of the time that it will take for a decision to be made. The facts clearly state that a matter in the Supreme Court can be heard, but will be decided over an extent of 5 years. Your Excellencies, given the urgency of this matter, the continuing violations that are in this case with regard to Surrogate D and the two children that at this current time have no identity, we cannot expect to wait 5 years for a decision to be made with regards to the issues that have been brought before this court. And therefore,
Counsel?
Yes, Your Excellency.
Would you say the respondent is delaying unnecessarily despite trying to expedite the hearing at the Court of Appeal, and also by vesting the custody of the children in the applicant? So in a way, we cannot really say they do not have an identity. Would you say that is still unreasonable? Because it's like, from the fact of the case, it's clear that the respondent has made sure or has taken steps to ensure that the children are well catered for, or they have a custody of where to be at the present moment. And there has been a kind of willingness by expediting despite the time frame. So what would you say about that?
Thank you, Your Excellency, for your question. With regards to the first question on whether or not the respondent state is unnecessarily delaying the hearing of the matter, we do not believe that the respondent state is unnecessarily delaying the matter. But the question is, there is a backlog of cases within the Supreme Court, and despite them saying that they will expedite the hearing, the expedition by the Minister of the Republic of Nkandu is uncertain. We are not sure if the decision will be made in less than 5 years. They've not made that they've not bound themselves to that decision. With regards to the fact that the custody of the children has been placed within the hands of Surrogate D, Your Excellencies, it is our submission that Surrogate D is not in a position to take care of those children, and that is why there has been an appeal of the decisions of the High Court and them challenging the constitutionality of the decisions of the High Court. And if those decisions are still pending, then the rights of those children as well have not yet been solidified or guaranteed in the Republic of Uganda. And that is why we appear before this court.
You may proceed, Counsel.
Thank you. Your Excellencies, as I've demonstrated, this matter is admissible before this court despite the fact that local remedies have not been exhausted, as I've already demonstrated. Moving on, Your Excellencies, to the substantive issues, I am dealing with the first substantive issue of whether or not the Republic of Uganda has violated particularly Article 2 and 4 of the Maputo Protocol and Article 2 and 3 of the African Charter with regard to, by its enactment of Article 55(3)(a) of the Surrogacy Act, as well as Article 55 Sub-Rule 6 of the Surrogacy Act, and the subsequent court's application of these provisions in Surrogate D's case. The applicant submits that the respondent state in both these situations have violated Surrogate D's rights. Article 2 of the African Charter provides for the right not to be discriminated on any grounds. Read with Article 3 of the African Charter, it provides that that there must be equal protection and under the law. It is our submission that this has not been done with regard to the enactment and the application of these provisions. Particularly, Your Excellencies, Surrogate D has been discriminated on the grounds of her reproductive choices and her sex. Article 55 Sub-Rule 3A of the Surrogacy Act mandates her as the surrogate mother to become the second parent of the children, while her spouse or civil partner has the choice whether or not to enter into such agreement or be bound by such responsibility. While Surrogate D or other surrogate mothers, even despite the fact that they are not carrying these children for themselves, but are doing them for the commissioning parents, are forced to take accountability or responsibility of these children. This, Your Excellencies, is an unequal unfair burden that is placed upon surrogate mothers who are not only providing the ability of commissioning parents and other parents who are not able to provide for themselves the children that they need. That being said, Your Excellencies, we submit that Article 55 Sub-Rule 3A and 55, particularly 55(3) Sub-Rule A, is a violation of Article 2 and 3. Moving on, or furthermore, in Article 2 of the Maputo Protocol, it provides that the member states must take actions or implement policies and laws that prohibit or curb discrimination. These acts, Your Excellencies, as I've already tried to demonstrate, do not do this. They do not curb any form of discrimination as they discriminate against surrogate mothers. They do not try and prevent this discrimination as surrogate mothers are placed in peril. Moving on, Your Excellencies, to the issue of Article 55 Sub-Rule 6, which provides for the prohibition of commercial surrogacy, we read Article 4 of the Maputo Protocol, which provides that a state must undertake to prevent all forms of violence against women. And particularly, they have provided for state obligations that a respondent must fulfill. And in the case of Equality Now versus Ethiopia, it was held that when a state fails in its duties, its tripartite duties to respect, to protect, and fulfill, then state responsibility arises. In this case, Your Excellencies, the enactment of these provisions, as well as the court applications of these provisions mandating Surrogate D to have custody of the children, of not taking into account the fact that she is unable to take care of these children, there has been complications that arise from the Surrogacy Act. This is a form of exploitation and violence that is meted against Surrogate D. Your Excellencies, in this slide, we provide that the applications of 55(3)(a) and 55 Sub-Rule 6 of the Surrogacy Act are a violation of Surrogate Deeds Act, and the court's application of these provisions was contrary to the international obligations to protect surrogate D as a woman in the Republic of Nkandla. If there are no questions for this court, I will cede the floor to my co-counsel. Thank you.
Go ahead. Go ahead.
Might it please the Honorable Court, Madam President, Your Excellencies, I am the second agent for the applicant, and I will be addressing this court on the second substantive issues as well as reparations. The first alleged issue regarding the second substantive merit regards Article 14 of the Maputo Protocol as well as Article 24 of the Maputo Protocol. The applicants herein submit that the respondent state has violated Article 24 as well as Article 14 of surrogate D's rights in terms as enshrined in the Maputo Protocol. Now, Your Excellencies, it is important for me to address the issue of the reservation that has been made by the state of Nkandla. The applicants humbly submit that the reservation entered into in terms of Article 14 as well as Article 20 of the Maputo Protocol should be held to be void on the basis that they go against the basic object and purpose of the Maputo Protocol. At Article 19C of the Vienna Convention on the Law of Treaties, which has been expounded in this court before in the case of Victoria Umuhuza versus the Republic of Rwanda, we continue to cite this case in order to establish to the court today that the reservation made by the respondent state in terms of Article 14 of the Maputo Protocol as well as Article 20 of the Maputo Protocol is inconsistent with its international obligations as it goes against the basic tenets, purpose, and scope of the Maputo Protocol. The whole entire purpose of the Maputo Protocol is to protect the women's rights, and women's rights are inextricably linked to reproductive rights. Now, making a reservation to Article 14 of the Maputo Protocol is tantamount to the respondent then ceding all responsibility with regard to the Maputo Protocol. Therefore, we plead with this court, we pray that this court finds that this reservation must be held to be inconsistent with the obligations.
Counsel?
Your Excellency.
Are you not trying to say the court should look into the sovereignty of the respondent? If you're urging us to rule that to void the reservation, is that not like trying to impede on the sovereignty of the respondent?
Thank you very much, Your Excellency. I state again the Vienna Convention on the Law of Treaties. It is the very treaty that whose some parts of it have been classified to become customary international law, Your Excellency. It is not a question of us or this court actually impeding or encroaching into the sovereignty of the state of Nkandla. It is this court ensuring that as the state of Nkandla enters into multilateral treaties, they are not going to be in a position to unjustifiably deny the rights upon which these multilateral treaties vest the recipients or beneficiaries of the rights of these multilateral treaties, the rights to enjoy them. Your Excellency, if we go on and speak to the sovereignty outside of weighing the rights of the women of Nkandla, then we would be unjustifiably, as this court is a human rights protector and arbiter, encouraging the state of Nkandla to violate the rights.
You may proceed. Thank you.
Thank you, Your Excellency. We humbly submit that once this court has found that the reservation entered into by the state of Nkandla with regards to the Maputo Protocol is inconsistent with its international obligations, we find that we have to lay out a case for the actual violation of the Maputo Protocol in terms of Article 14 and Article 24. Article 14 of the Maputo Protocol speaks to the right to health and reproductive rights. In terms of its content, I rely on General Comment number 2 on general comment number 2 on Article 14 of the Maputo Protocol, cited by the Committee on the Special Protection by the Committee on the Maputo Protocol, Your Excellencies. It has been said that, firstly, the right in Article 14 contains, firstly, in the first limb, the right to control one's fertility. Secondly, the right to decide or determine maternity. Thirdly, the choice of contraceptives, including birth control. We humbly submit that the state of Nkandla, firstly, in allowing or in failing to actively move the social and cultural bar to a point where women are allowed to make their own determination with regards to their reproductive health without having this decision made for them by their male counterparts, is a violation, firstly, of the obligation as enshrined in the Maputo Protocol for states to move in such a manner that women's rights would be secured. Meaning that if there are any traditional, cultural ideologies and practices, the state ought to move in a way that it allows for us to do away with these. Therefore, we humbly submit that the fact, as the facts allege, that Mansa, a man, made a decision on behalf of Surrogate D with regards to her reproductive rights constitutes a violation. The state had a positive obligation to prevent such instances from happening. Therefore, we humbly submit that the state has failed in its obligation to protect Surrogate D's right to control her own fertility. Secondly, the dignity which underpins, the aspect of dignity which underpins human rights mandates that the freedom of making this choice must be preceded or must be allowed without interference from either from the state or from third-party actors. Therefore, the failure of the state to ensure that Surrogate D is able to make choices of her own without the impediment, without having to have them made on behalf of herself by another person, then means that these rights, or there has been a manifest, set up a manifest violation of the rights of Surrogate D, Your Excellencies. We move on to the second limb of this right, being particularly Article 24 in the Maputo Protocol, the need for protection or special protection for women in need. The special protection here, Your Excellencies, is that Surrogate D is a widowed woman. She's not only a widowed woman, she's a widowed woman who has been forced to enter into surrogacy agreement in order to a surrogacy arrangement in order to make or to safeguard the life of her daughter. She has sacrificed herself in place of her daughter. Once again, we humbly submit that this was not supposed to take place in a state where the government has actively given or has actively agreed to protect women's rights. We see a situation where Surrogate D is already now sacrificing and taking the place of her child in order to safeguard her innocence. Your Excellencies, we feel that, or we submit to this court that the fact that Surrogate D had to sacrifice herself in place of her child means, as a widowed mother, as a widow and as a mother, means that the state has failed to create adequate protections in place to ensure that Surrogate D and women like her, similarly situated women like her, do not have their rights violated. Further, as a surrogate and other women who enter into surrogacy agreement, the state has not only licensed GISA, the clinic that Surrogate D has gone to for this procedure. The state, because of its licensing, has an obligation to monitor and ensure that everything that this clinic does is above board. The state failing to do so, that means the actions of GISA and FDC clinic are attributable to the state on account of the fact that the state has a duty to monitor and has a duty to monitor and supervise entities through or non-state actors through which it licenses. Therefore, Your Excellencies, we humbly submit that we have made out a case for the violation of Surrogate D's rights with relation to Article 14 and Article 24 of the Maputo Protocol. The second limb here is that there has been a violation with regards to the best interest of the child. This best interest principle is enumerated in Article 4 of the African Charter on the rights and welfare of the child. It is further seen in Article 3 of the United Nations Declaration on the Rights of the Child. Your Excellencies, we humbly submit before this honorable court that the best interest of the child must take precedence in this matter. It is our submission to this court that placing these children in the hands of surrogate D goes against the best interest of the child. And the African court, in the advisory opinion of PALU, held that this right, or the best interest of the child it has a far-reaching scope and its standards cannot be diluted. In all matters, Your Excellencies, that involve a child, we cannot have an impediment or limitation on this right. The right cuts across all conceivable public and private life. It is the applicant's submission that placing these children in the care or under the guardianship of surrogate D, who is a sick individual, she's physically unwell and physically incapable of rendering care to these children. Secondly, she does not have the means or financial means to provide a suitable environment for the growth and development of these children. Your Excellencies, it is our humble submission, and it is with reliance on the fact, a point that surrogate D already has another daughter at home who she's failing to take care of. What more of 3? And we humbly submit that for these 2 children born out of the surrogacy, having them placed in the care of surrogate D would not act in their best interest. And when this court engages in this exercise of the best interest, it has a weighing of rights that it has to do. However, the paramount consideration, as we have already said, should be where the child's interest would best be suited. Where would the child's growth, development, health be best met? With a sick mother or elsewhere, Your Excellencies. This is our humble submission to say, in the state of Nkandla, in enforcing or in putting these children within the care.
Counsel.
Your Excellency.
I'm aware that the Court of Appeal made an order that the children should be placed in a state facility pending the recovery of surrogate D. So how does that still affect the best interest of the child? Because the court had already given room for the sick mother to recover, and then the law is clear on who has to have the custody if the law is not followed. So how does that still affect the children?
Yes, Your Excellencies, much obliged. Your Excellency, we humbly submit to the court that once surrogate D recovers, in the event that she recovers on account of the denial of the state of Nkandla's denial to grant her health care, we humbly submit that once she recovers, she still has to take care of these children. The order of custody has already been granted in her. The state of Nkandla, through its courts, has refused to grant the commissioning parents custody of these children. Therefore, Your Excellencies, it goes down to the point that once she has already recovered and the children are back in her care, it would act against their interest to have her continue to take care of them. Now, Your Excellencies, the last point that we wish to make, or the last claim that we wish to make, is that, well, this court entertained the issue of the reparations that are due to Your Excellencies with
Counsel, would you want a little bit of time added? Are you requesting?
Yes, Your Excellency.
How much time?
May I have 2 minutes to wrap up the issue of reparations?
2 minutes you have.
Your Excellency. Thank you very much. The issue of reparations is, this court is empowered to make reparations on account of Article 27.1 of the protocol, or on the establishment of this very court. Your Excellencies, we humbly submit that the court is required to make reparations once, or the basis of reparations has been established in the case of XYZ versus Benin, wherein the court has held that reparations are only awarded where the responsibility of the state for an internationally wrongful act has been established, and a causal nexus between the state's actions and the harm caused has been established. It is the applicant's submission that we have sufficiently set out the internationally wrongful act in denying and violating the rights as contained in various human rights provisions, as well as the causal nexus of those violations. Therefore, we believe that the court is competent enough to make an award for reparations. We humbly submit to this court that, firstly, the law or the Surrogacy Act, at Article 55(3) and 56, should be declared to be in violation of human rights on basis of the African Charter on Human and People's Rights on basis of discrimination. That the continued that the actions of the state of Nkandla through its court constitute a violation of Surrogate D's rights in terms of the Maputo Protocol at Article 14 and Article 24, as well as the Article 4 of the African Charter on the rights and welfare of the child.
Let me take you back on your complaint about Manza making decisions for surrogate.
Yes, Your Excellency.
Why are you complaining? That is very African, and the Maputo Protocol recognizes customary law.
Much obliged, Your Excellency. Inasmuch as the social standing and the cultural and traditional principles of a society might be existent, they should not be used, Your Excellency, to prevent the progression of women's rights. Therefore, Your Excellency, our complaint stems from the fact that in a country that has already shown or that has already become a signatory to the Maputo Protocol, all reservations concerned, we ought to have seen a positive move, not just the state sitting on its loins and saying, well, it's our culture, then we're not going to do anything. Men can continue to make decisions on behalf of women. We should have seen an active move, an active step with relation to how the state empowers the rights of women. Thank you, Your Excellency.
Thank you very much. Thank you very much. Bailiff, did they keep time? They stuck to time?
Presiding Judge, the oral submissions presented by the complainants were within the allocated time.
Thank you very much. May I now call upon the respondent team? Please take the floor.
Presiding Judge, Honorable Justices, greetings once again. My name is Kadamba Naomi, appearing as the lead counsel for the respondent, the Republic of Nkandla. Lead counsel will guide this court through our standing on the preliminary issues of jurisdiction and admissibility, as well as the merits of the first and second claim. Seeing that our submissions on the first merit on the withdrawal, Your Excellencies, highly impacts our standing on jurisdiction, our structure of submission will be as follows. We will begin with jurisdiction, and then the merits of the first issue and complete on preliminary issues with admissibility. After that, we will proceed to submit on the second, third, and fourth merits in that particular order. And if this structure suffices to the court, we will begin.
Go ahead.
Your Excellencies, on the 21st of March 2018, this Honorable Court rendered a judgment in Mariam Kouma and Usman Diabate versus the Republic of Mali, where in paragraph 25, this court explained that it must always conduct a preliminary assessment of its jurisdiction and define its boundaries. In paragraph 26, the court proceeded to explain that it must always confirm its possession of material, temporal, territorial, and personal jurisdiction. We align ourselves with the submissions of the applicant in as far as material, temporal, and territorial jurisdiction go, but refute any claim that this court is furnished with the requisite personal jurisdiction. Our standing on personal jurisdiction, members of the bench, is guided by the provisions of this court's protocol in Article 5.3, where non-governmental organizations with observer status to the African Commission are indeed given local standing before this court. Allow us to guide you, Your Excellencies, to paragraph 54 of the fact pattern. We learned that Life Givers Watch International indeed has observer status to the African Commission. And yet this local standing in Article 5.3 of the protocol is not one that is absolute. It is dependent on the fact that the respondent state must have deposited the declaration of compulsory jurisdiction under Article 34.6. In paragraph 58, members of the bench, we learn that the respondent state withdrew this declaration, and it is our standing that the withdrawal is valid. This will guide us to our submissions on the first merit, Your Excellencies. We start by laying out a roadmap for the bench. We will be responding to the submissions of the applicant in 5 subheadings. The first being state sovereignty, the second, the retroactive application of the law, the third, the maturity of the notice, The fourth, the application of the VCLT, and finally, the third-party rights enshrined in the withdrawal. To begin on state sovereignty, Your Excellencies, we want to invoke this court's decision in the 2020 decision of Glory and Landry versus Benin, where in paragraphs 2 and 6, this court explained that forcing a state to remain under the jurisdiction of this court, even after it has shown its intention to withdraw, is infringing on its sovereignty. In paragraph 6, the court explained that the withdrawal, or rather the deposition and the subsequent withdrawal of the declaration, is one that is bound by the principle of state consent. With this in mind, Your Excellencies, we do acknowledge the fact that the law does not apply retroactively. We seek, however, to persuade this court to the contrary by invoking the decision of the American Supreme Court in USA versus Carlton, where that court established two circumstances to explain the conditions under which a law can be applied retroactively. The first part of the test, members of the bench, is that the retroactive application of the law should serve to protect a legitimate interest. The legitimate interest that is concerning to the respondent in this case is the fact that the applicant has failed to exhaust local remedies, as we will show in our submissions on admissibility. And we request that this court joins us in safeguarding our sovereignty and the effectiveness of our judiciary. The second part of the test, Your Excellencies, is that there must be a modest period of retroactivity. The court explained the modest period of retroactivity as being the time between when the new law came into force and when the action was done. In our case, the time between when the applicant seized this court and when the respondent withdrew. The court explained that a modest period of retroactivity, members of the bench, is a period of just about 1 year. And we invite you to the second annex of the fact pattern. The applicant seized this court on the 29th of January 2024, and we withdrew on the 20th of February 2024. This being a period of just about 3 weeks. Seeing that the two-part test, Your Excellencies, has been satisfied by the respondents, we pray that this court applies our withdrawal retroactively to find that it indeed affects this court's personal jurisdiction on the case currently being heard on the 5th of December 2024. The lead agent for the applicant spoke about the 12-month notice, which has been established in case law, as well as the Vienna Convention on the Law of Treaties. Allow us to begin by addressing the applicability of the Vienna Convention. And we will do this by invoking this court's judgment in paragraph 54 of Ingabire Victoria Muhonza versus Rwanda, where this court established that while the protocol in itself is subject to the law of treaties, the declaration is unilateral in nature and that it is therefore not subject. In this court's corrigendum on the same case, it established that this court can only apply the Vienna Convention only in analogy and not in any way in a way that is binding against the respondents. The reason given by the court, Your Excellencies, in paragraph 62 of the same case against the state of Rwanda, for why the 12-month notice is so important, Your Excellencies, is so as to prevent the abrupt suspension of the rights of the third parties being citizens and non-governmental organizations. It is our standing that in no way has our withdrawal affected the rights of the third parties. And to this effect, allow us to invoke the 2022 judgment of the African Court in paragraph 60 of African Commission versus Kenya, where this court established that in case the respondent has withdrawn the declaration, therefore affecting the local standing of the third parties, the non-governmental organizations and the citizens, the African Commission can seize this court on behalf of these third parties. In no way, therefore, Your Excellencies, has our withdrawal rendered the remedies offered by this court non-justiciable.
Counsel, don't you think your withdrawal is preemptive of the decision of this court, especially when there is a claim of continuous violation of the rights? And then also on the issue of the time lapse, do you not think the court also have the discretion to entertain this matter, even though the time lapse is not up to 12 months, considering the sensitivity of this, the sensitive nature of this case?
Your Excellency, on your first question, allow the respondent to answer by invoking the principle of good faith, which is recognized as a customary international law principle. We will submit in two main arguments that our withdrawal was done in good faith. For the first, Your Excellencies, allow us to guide you to paragraph 42 of the fact sheet. Nkandu is at a time when we are revising our different laws, Your Excellencies, and in paragraph 42, we see that the regulations and the guidelines to the Surrogacy Act are currently being assented. The withdrawal, members of the bench, is just one of the moves that the state is taking during a time when we are revising our different legislations. Concerning the exact wording of paragraph 58, we do submit that indeed our withdrawal is in reaction and in protest to the fact, not to the fact that the applicant has seized this court, quite to the contrary, to the fact that the applicant has come before this court before exhausting the local remedies which are offered, by our domestic courts. Answering your second question, Your Excellency, will help us move to our submissions on admissibility in relation to the urgency and the sensitivity of the case at hand. On admissibility, Your Excellencies, this court is guided by Article 56 of the African Charter, particularly Article 56 of the African Charter, but our attention is drawn to Article 56(5) of the Charter, which demands that the applicant always exhaust local remedies before seizing this court. The African Commission explained in paragraph 59 of Promoting Justice for Women and Children versus DRC that the reason the applicant must exhaust local remedies is to, 1, give the respondent state a chance to redress the violations, and 2, to prevent this court from being used as a body of first resort at the cost of its effectiveness. The African Commission proceeded in paragraphs 31 and 32 of Doda Jawara versus the Gambia to explain only 3 circumstances under which the applicant will be exempted from having to exhaust local remedies. The 3 being if the local remedies are not available, in that the applicant cannot pursue them without impediment in practice, if the local remedies are not efficient, and if the local remedies are not sufficient. On availability, Your Excellencies, allow us to guide you to paragraph 5 of the fact sheet. Our country, members of the bench, houses a very effective judiciary with 44 courts in total. A Supreme Court in Kasundu, a Court of Appeal in Kasundu, 6 High Courts, and 36 District Courts. Any submission by the applicant that our local remedies are unavailable is misleading to this bench. On effectiveness and sufficiency, allow us to begin by invoking the decision made in 2014 by this court in Zongo versus Burkina Faso, where in paragraphs 102 and 103, this court explains that the effectiveness of a local remedy does not mean its ability to adhere to the demands of the applicant, but instead the ability of that local remedy to solve the problems which have been presented by the applicant. In Sadiq versus Denmark, Your Excellencies, in paragraph 6.5, the Committee on the Elimination of All Forms of Discrimination explained that mere speculation on the effectiveness or sufficiency of a local remedy does not preclude an applicant from having to pursue them to fruition. The applicant passionately submitted on the fact that our judicial system is one that has been unduly prolonged. We submit to the contrary, and we also seek to persuade this court by reminding this bench that the applicant has disregarded an ongoing domestic litigation. On the timelines, Your Excellency, allow us to invite you to the second annex of the fact sheet. The applicant seized the Supreme Court on the 26th of November 2023 and moved directly to the African Court on the 29th of January 2024, despite the fact that the hearing at the Supreme Court, which was slated for the 12th of March 2025, had not been concluded. We bear cognizance, Your Excellencies, of the urgent and sensitive nature of this case, and we want to persuade this court that the judiciary of Nkandu is aware that the matter needs immediate judicial intervention. To this effect, allow us to invite you to paragraphs 51 and 52 of the fact pattern. In paragraph 51, Your Excellencies, the Court of Appeal recognizes the urgent nature of the case at hand, and the Court of Appeal proceeds to say that it's going to prioritize the case. And that is why in paragraph 56, Your Excellencies, the judgment is given by the Court of Appeal on the 13th of November 2023. This is 3 months after the Court of Appeal was seized, inasmuch as normally cases at the Court of Appeal take up to 2 years. We pray that this court finds that the judiciary, again as seen in paragraph 56, where the Chief Justice of the Republic of Nkandu comes out to acknowledge the sensitivity of this case and to promise that they are going to prioritize listening to this case. And that is why the Supreme Court gives a waiting period of 15.5 years and not the normal 5 years. Your Excellencies, we do acknowledge the sensitive nature of the case as it relates to surrogate D's health and the well-being of the children. But we pray that this court considered the backlog that our judiciary is facing and finds that indeed we have prioritized surrogate D's case. On the preliminary issues, Your Excellencies, we are therefore of the standing that this court lacks jurisdiction, that the applicant lacks local standing, and that the issues are inadmissible. In the rare occasion that this court finds contrary, we will seek to proceed with the submissions on the second, third, and fourth merits as we practice our right to reply, seeing that a case has already been meted against us. On the second issue, Your Excellencies, we are of the standing that in no way has the enactment of the Surrogacy Act promoted discrimination against women, or the violation of the Maputo Protocol, particularly Article 2 on the protection from discrimination, Article 4 on the right to life, integrity and security of women, or the African Charter in Article 2 on elimination of discrimination and Article 3 on equality before the law. Your Excellencies, Article 55(6) of the Surrogacy Act indeed prohibits commercial surrogacy. In 2018, the United Nations Special Rapporteur released a report on surrogacy, where research reveals that commercial surrogacy tends to resemble the sale of children, and that it exposes children and women to exploitation, and that financially vulnerable women are coerced into surrogacy agreements because of their financial desperation, which limits their autonomy and their ability to give informed consent. We seek to align ourselves, Your Excellencies, with the defense given by France in paragraph 60 of Menesson versus France, where the respondent state claimed that their ban on commercial surrogacy was not in any way intended to cause financial hardship, but instead that it was a move by the state to protect the dignity of women. On the realization of the right to health, Your Excellencies, indeed in paragraph 8, we learned that our Bill of Rights only recognizes education as the only socioeconomic right. But yet we are bound by the provisions of the International Covenant on Economic and Social and Cultural Rights, which we have ratified, to take progressive steps towards the realization of the right to health.
Council, by prohibiting commercial surrogacy, are you not infringing on the right of reproductive autonomy of surrogacy?
Your Excellency, we note the concern of the bench, and we'd like to invite you to paragraph 2 of the fact sheet. Our women, members of the bench, are women who are struggling, and we bear cognizance of their difficulties. Our concern is that if we allow commercial surrogacy, as highlighted in a 2018 report by the United Nations, which you just quoted, it's going to take away their autonomy and their ability to give informed consent. As a state, we must recognize that their financial desperation might lead them to make decisions which they think will help better their financial situation. And this is the reason the state has it in mind when banning commercial surrogacy. In the same breath, Your Excellency, we are looking at our Surrogacy Act, and in paragraph 2, we learned that the Surrogacy Act is currently back to the legislature so that the regulations and guidelines to the same can be assented. We therefore request that the applicant, we are therefore of the standing that the applicant, that the fact that the applicant has come to this court is premature because our laws are ever evolving and that our laws are flexible. To wind up,
you have 2 minutes extra, which you can share between the two of you.
Thank you. Lead counsel will take 1 and donate 1 to the second counsel. To end up on our submission, Your Excellencies, we do seek to invoke this court's decision in Purohit and Muru versus the Gambia, the African Commission's recommendation, where in paragraph 84, the African Commission recognized the duty of the state to progressively realize the right to health, but found that this duty might be constrained by financial resources. We seek to persuasively invoke Article 20 of the Kenyan Constitution, particularly 25, Your Excellencies, where it is written that where a state cites lack of resources as an excuse for failing to realize the socioeconomic right, it must prove that it indeed has shortage of resources. And to this extent, we invite you to paragraphs 3 and 4 of the fact sheet. Members of the bench, our country has a 44.7% country poverty rate, with 32% of our citizens living in extreme poverty. We are facing an economic recession post-COVID-19 with an inflation rate of 15%. And more worryingly, we rely on foreign aid as one of our major sources of revenue. Socioeconomic rights, Your Excellencies, we acknowledge that our healthcare system indeed has a couple of limitations, but we are of the standing that these limitations do not in any way stem from discrimination, that they stem from socioeconomic challenges which are facing the entire population, that our resources do not allow us to focus solely on each particular group, and that is why through the budgetary allocation, as we learn in paragraph 4, and through the laws in paragraphs 23 and 42, the state is taking the strategy of advancing healthcare as a whole and for everybody. We therefore, in relation to the second issue, pray that this court finds that in no way has the enactment of the Surrogacy Act caused discrimination or inequality before the law against women. And having reached the end of our submissions, the lead counsel will cede the floor to the second counsel. Thank you.
Thank you very much, lead counsel. Second counsel, please go ahead. That extra one minute.
Much obliged. Presiding Judge and other members of the bench, greetings. As previously introduced, my name is Anthony Makawe Rungu, appearing before you as the second counsel to the respondents, the Republic of Nkandu, I shall be using 13 minutes of the court's allocated time to adduce on the third and the fourth issue. If there are no preliminary concerns, I beg to proceed.
Please go ahead.
Much obliged. Your Excellencies, before proceeding to the substantive issues, it is right that the Second Council remind this court that the respondent state is a developing nation. And like most developing nations within the African Union, they are faced and plagued by a lot of factors, including defunct governments, wars, and as the merits of this case provide, poverty. And in that regard, it is our submission with regards to the third issue that we have not in any way violated Articles 14 and 24 of the Maputo Protocol, Article 16 of the African Charter, or even Article 4 of the African Charter on the Rights and Welfare of the Child. To this, I shall respond to the applicant's arguments in three limbs of arguments. First, in response to their citations of paragraphs 22 through 35, where they have cited that due to the lack of informed consent, as well as the actions and the omissions of GISA and DFC can be traced back to the state of the Republic of Kandu. However, they have failed to attribute that under the four substantive tests, under Articles 4 through 8 of the draft Articles on State Responsibility, that only confer 4 types of responsibility. Attributability through a person exercising governmental authority, through an organ exercising the same, through an organ directed or controlled by the state, or through an organ at the disposal of another state. It is the firm submission of the respondents that GISA and DFC are not in any way directed or controlled by the respondent states. We are aware of paragraph 15 that duly states that GISA is a duly registered surrogacy agency operating within the Republic of Kandu. However, we are also guided by the precedent stated by the African Commission in Center for Economic, Social and Cultural Rights versus Nigeria, where the government of Nigeria, from paragraph 66, was not held liable merely because the Nigerian oil company was present within the Nigerian state, but because the Nigerian government took part in production of the oil as well as in the destruction of the homes of the Ongodi people. Hence, it was the duty of the applicants to show that the respondent states directed or controlled the actions and the omissions of GISA, to which they have failed to do so. Moving on, in response to their arguments on the alleged violation of the sexual, reproductive and health rights of surrogate D within the Republic of Kandu, Your Excellencies, we are not in contention with the applicants, that indeed every individual is entitled to the best sustainable standard of health within their state. However, we are guided by General Comment number 14 by the Committee on Economic, Social and Cultural Rights, specifically paragraph 31, that sets off 2 broad limitations in which social, economic and cultural rights can be realized. That is number 1, based on the maximum available resources, and number 2, based on the steps that can be taken in order to realize it, or otherwise known as progressive realization. And Your Excellencies, this form or these limitations were acknowledged by the African Commission in Media Rights Agenda versus Nigeria of 2000, when paragraph 31, it stated that the reality of the limitation of social, economic and cultural rights is due to the fact that states are not equally endowed in terms of resources or even economic obligations. And hence, the issue of contention before this court, Your Excellencies, is how do we balance the realization of economic and cultural rights as well as the maximum resources thereof, specifically even herein with regards to surrogacy agreements. And Your Excellencies, I would like to invoke, by virtue of Article 61 of the African Charter, the case by the European Court of Human Rights, which tried to balance this rationale. That is Alev and 2 others versus Albania of 1996. Where, Your Excellencies, the issue in contention before that court is that the applicants, by virtue of the Albanian Artificial Procreation Act, could not be able to use donor gametes through in vitro fertilization in order to raise a family of their own. They filed a petition before the European Court alleging that their sexual, reproductive and health rights had been infringed. However, notwithstanding this, the court, in its judgment from paragraph 78 to 81, stated that notwithstanding the cultural and scientific impediments related to that procedure, Albania's economic landscape could not guarantee the applicants' rights, noting that Albania at the time was already suffering a HIV and AIDS crisis as well as a deteriorating currency, and hence it would have been improbable for them to focus on one specific health facet alone at the detriment of the entire health populace. And to that, we draw a nexus to the merits of this case. Your Excellency, is where I shall guide your attention to paragraph 3, where we note 3 things. That number 1, the respondent state poverty rate is at 44.7%, where herein 2,272,000 of the 7 million people living within the respondent state are living in extreme poverty. And lastly, even as submitted by my co-counsel, we rely on foreign aid for infrastructure as well as capital. Nonetheless, in satisfaction of the second test enunciated under General Comment number 14, we have done our best in order to progressively realize the sexual reproductive rights of women within the Republic of Kadu, to which I shall guide your attention to paragraphs 4, paragraphs 23, as well as paragraphs 42, where we learn that in paragraph 4, despite the COVID-19 pandemic that ravaged the entire global community, Your Excellencies, our budget health allocation is at 10.5%, the highest it has ever been. In paragraph 23, in 2019, we adopted the reproductive health policy in order to realize the sexual reproductive rights of women. And in paragraph 42, in a swift response to the alleged violations in surrogate's case, we adopted a moratorium on all forms of assisted reproduction, pending the assent of the Surrogacy Act 2017 regulations. And hence, it is based on this test, Your Excellencies, that we have progressively, not in as much as we wanted to, but progressively realized the right to health, and more specifically, sexual reproductive rights of women within the Republic of Kanu. Moving on swiftly.
Council?
Yes.
Are you now saying because you've prioritized some aspects of the general health needs of the society, the life of surrogate D should be left to be at stake, even when there is, in the face of emergency, considering the health needs, and the only basis for refusing our healthcare services was because she conceived through surrogacy, or because she went through surrogacy while other mothers were provided postnatal care. So what is the justification of that in the face of providing healthcare services, the same services to other members of the society?
Much obliged, Your Excellency. In answering your question, I will first like to rely on the rationale again by the African Commission in SERAC versus Nigeria, where in paragraph 59 it stated that social, economic, and cultural rights cannot be achieved in a short period of time, but due to the realities of the world as well as the difficulties faced by most developing nations. Indeed, it is inasmuch we sympathize with surrogate's case, and we do understand that in some instances, maybe and indeed, social economic rights can be limited. However, we also make reliance on the rationale that was employed by Justice Mumbi Ngugi in the Mitubel welfare case versus the Attorney General of Kenya, as well as the Kenya Airports Authority, where it stated from paragraph 78 that the realization of social, economic, and cultural rights is supposed to be systematic in nature, and that what is needed to be seen is a step-by-step basis. To which it is the respondent's submission that in as much as we have not in entirety realized the full extent of social, economic, and cultural rights, we are taking step by steps within our available resources in order to fully realize them. And as I shall tie your answer to my submission and reparations, we do sympathize with surrogate D. And as such, we are willing, as the respondent states, to cater for the economic relation, for the substantive costs in order to take surrogate D for treatment, as well as to remove the womb associated herein due to postpartum hemorrhage in order to realize the best interest of the child. Thus, I shall now move to the my last limb of argument on the best interest of a child principle, if I may be allowed to.
Please go ahead.
Yes, indeed. Lastly, this being the most contentious issue before this court, it is our firm submission that we have realized Article 4 of the African Charter on the rights and the welfare of the child. Your Excellencies, we do agree with the applicants that in all spheres, whether public or private, it is the best interest of the child that shall be taken into consideration. And we acknowledge the Court of Appeal's efforts in order to realize this. What the applicants have failed to mention, however, is that the best interest of the child is not absolute, and it has certain limitations, to which was acknowledged by the European Court of Human Rights in Follon and Bouvet versus France, which stated that especially in order to balance the best interest of the child, as well as surrogacy cases or surrogacy agreements, 3 factors must be taken into consideration. Number 1, the social development rights of the child. Number 2, the genetic relation of the parties to the surrogacy agreement. And number 3, the intention of the parties to the surrogacy agreement. First, with regards to the first factor on the social development rights, we do acknowledge that as guided by paragraph 20 as well as by paragraph 2, Surrogate D hails from Talaka district, the least developing district part of the Republic of Kando, and hence economically she cannot be able to guarantee the rights of the child herein. However, two factors remain. Number one, the genetic link, and number two, the intention. With regards to the genetic link, Your Excellencies, we are guided by the court in Folon versus Bouvet that in paragraph 153, it stated that children born as a result of surrogacy have the legal right to have the legal right and entitlement to have the relationships with their biological parents guaranteed. This is due to their right of certainty of parentage. And hence, I shall direct your attention, Your Excellencies, to the last sentence of paragraph 28 of the fact sheet, where we learn that not only is Surrogate D the gestational mother, but her ovum was harvested in order to conceive those two children. And hence, it is in the best interest that those children are guaranteed the certainty of parentage by having Surrogate D take full custody. The last and the most important factor to take note, Your Excellencies, is the intention of the parties to the surrogacy agreement. Your Excellencies, the court in Folon in paragraph 167 stated that the purpose of a surrogacy agreement is not for the sale and the transfer of children, but for conferring full parental rights and balancing the need of the ability to have the children as well as the need thereof in general. And what the applicants have failed to mention, Your Excellencies, is that in paragraph 36, when the commissioning parents learnt of the fact that Surrogate D had conceived birth to two children, they informed the surrogacy agency that they only wanted one, noting that the excuse being that they had bargained for only one child, and proceeded to pay $1,000 in order to stay with that baby boy. This manifestly, Your Excellencies, translates the surrogacy agreement into a sale of goods contract, which, Your Excellencies, I shall echo the words of the United Nations General Special Rapporteur report on child trafficking and child exploitation, number 168 of 2018, that stated in paragraph 67 that in most developing nations, surrogacy is used for child trafficking as well as a means and method for the sale of children. And hence, it is in the best interest of the child that Surrogate D retain full and parental custody rights. Now, turning to even a greater contention is that on one hand, we have the commissioning parents who only want one child, and on the other hand, we have Surrogate D who does not even want the two children. This leads me now to the biggest submission on our reparations, where we invite this court to be guided by the Supreme Court of Victoria in ZD and others versus the Secretary of Department of Health of 2022, where it stated that in balancing these rights, it issued a co-parental order, directing that the commissioning parents take the economic and financial capabilities of raising the children while the surrogate parents retain the custodial rights. And in this case, we marry that situation here. And we invite this court to direct that Hudon and DN take the economic aspect of raising the children while Surrogate D retain the full custodial and parental rights in order to fully guarantee the best interest of the child. And even as I had earlier mentioned, we sympathize with the situation of Surrogate D, and the respondent state is willing to accommodate the extent of the cost in relation to replacing her womb due to postpartum hemorrhage in order, not for the extent of really Surrogate D, but to ensure that the children who have been conferred to her have the right to social development, Your Excellencies. And hence, it is our firm submission that those are the only two forms of reparations that they should guide this court. With the remaining reparations that the applicants have cited, we echo the words of this court in Zongo and others versus Burkina Faso, where this court stated in paragraph 68 that the existence of a mere violation in itself is not a cause for reparation, but it is the duty of the applicants to show a causal link between the alleged violation and the harm suffered. And it is the firm submission of the respondents that the applicants have failed to establish this causal link, and hence any other form of the reparation that they may seek before this court is unsubstantiated. Singh.
Okay, Counsel, are you not contradicting your own argument by imposing the financial obligation of raising the children in the commissioning parents while arguing for the custody of the same children in Surrogate D? And then you are coming out to say you are promoting the best interest of the child. Did you take the psychological well-being of the children into consideration in making this submission?
Much obliged, Your Excellency. In making our submission, In relation to that, seeing that my time is up, I hope I can be granted a discretionary 1 minute to answer the question as well as to state our prayers.
You get the 1 minute.
Yes, much obliged. Our main submission with regards to the best interest of the child is that based on the remaining two factors, that is the genetic link and the intention of the parties, that it is in the best interest that surrogate D retain custody. Now, our submission on reparations for the commissioning parents to take the economic obligation is in order to balance it. Your Excellencies, we learn under paragraph 20 that surrogate D does not have the financial capabilities to raise those two children. And hence, in order to balance the best interest as well as the social development rights of the child, we ask this court to be guided by the rationale in ZD that to allow surrogate D to retain the full custody while directing Hudon and Dian to retain the economic and financial obligation of raising those two children in order to effectively balance these two provisions. Hopefully I have answered your question. Much obliged. Based on the submissions of both councils, we thus invite this court to adjudge and declare that 1, this court does not have the jurisdiction to hear this matter and that the matters herein are admissible. To declare that the applicants lack the locus standi to present these merits before this court. However, in the event that this court finds that it has the requisite jurisdiction, the matters are admissible and the applicants have locus standi, we invite this court to affirm the provisions of Article 55.3a as well as Article 55.6 of the Surrogacy Act 2017 that they do conform with international laws, to affirm that indeed the respondent state has adhered to the best interest of the child principle as well as the provisions of the Maputo Protocol and the African Charter, to lastly, to order and direct that Hudon and Dian take the economic and financial obligation of raising the two children, and lastly, Your Excellencies, to award the cost of the suits to the respondents. Much obliged, and I shall cede the floor back to the bench for further directions.
Thank you very much, respondents, councils. Do you wish, the applicants, councils, do you wish to make a rebuttal?
Yes, Your Excellencies. Your Excellencies, we first turn the court's attention to the issue of attributability as raised by the respondents. Your Excellencies, in the case of Human Rights NGO Forum versus Zimbabwe, it was held that states can be responsible for acts of private individuals where there is a lack of diligence on part of the state to prevent violation of rights and effectively provide and effectively bring perpetrators to justice. Your Excellencies, we draw the court to paragraph 34 of the facts, wherein the Department of Social Protection in Nkandu conducted an investigation following the media reports, Your Excellencies. They went there and they told the ladies or the surrogate women in Nkandu to actually conform to these illegal contracts that they have been into. So, Your Excellencies, the question that they raised to say that, well, their actions are not attributable in terms of the authority above cited, Your Excellencies, rebuts their case in its entirety. Secondly, with reliance on the Egyptian Initiative for Personal Rights and Inter-Rights, Your Excellencies, we submit the point that failure to investigate and to investigate effectively towards an outcome that will bring perpetrators to justice shows a lack of commitment to take appropriate action by the state. It is further attributable to the state in and of itself that they failed to take proper steps, Your Excellencies, in order to remedy this matter. They bring an issue of progressive realization on account of financial means or the economic standing of the country. Your Excellencies, I draw the court to paragraph 50 of the facts, the very last paragraph, the very last 3 sentences of the paragraph, wherein it states that the major excuse for treatment refusal in all the hospitals was that complications arising from surrogacy cannot be treated at the expense of the government. Not that the government does not have the means to address the complications, simply that because I got these complications as a result of surrogacy, I cannot get access to health. We submit, Your Excellencies, that this further shows the discriminatory element that we continue to highlight. Secondly, that, Your Excellencies, it is a denial of the right to health, particularly that of access, Your Excellencies. Therefore, the point of progressive realization cannot stand in today's proceedings. We draw the court, lastly, to the point of the best interest of the child. It is funny that they talk about surrogate D's ova, and they conveniently forget to mention that it was blended with NJ's ova, which means these children, Your Excellencies, have two biological mothers. If really the biological link is their consent, then AJ and NJ, a better suited candidate, should be considered in the best interest or amongst the consideration for the guardianship of these children. Your Excellencies, we find that the points that they have submitted to this court are insufficient, and the court should find in our favor. Much obliged, Your Excellencies.
Thank you very much. Do you wish to make a sub-rebuttal? Would you like to? Thank you very much.
Much obliged, Your Excellency. I shall make my rebuttals in the following limbs. First, on the attributability that we cited and that they have rebutted, our main argument was in the actions and the omissions of GISA as well as DFC. And it was our main argument that they have failed to substantiate this under Articles 4 through 8. Notwithstanding the actions of DSD, we submit before this court that the actions of DSD are practical in nature, as it will have been improbable for DSD to void the contracts, because herein, voiding a contract in this situation could not even have guaranteed restitution. Your Excellencies, restituting the surrogate mothers will try even meaning allowing or trying putting the children back in the womb, and hence the actions of DSD in this situation can be in an essence practical. With regards to the argument on failing to take proper steps, the applicants have failed to mention with regard the provisions of paragraph 23 as well as the provisions of paragraph 42, where we have taken progressive steps, Your Excellencies. Progressive steps in this nation means steps that are in alignment with the maximum available resources as well as the steps that the state can take. We have taken legislative steps as echoed under paragraphs 23 and 42, and we have sympathized, Your Excellencies. They have cited paragraph 50, where we do acknowledge that at the expense of the government, surrogate D could not get medical attention, and we sympathize. And as such, even as submitted in our reparations, we have offered to allow how do I put it, to cater for the expenses of surrogate D in order for her, not especially for her, but also to realize the rights of the children. Lastly, is again on the point of progressive realization. The applicants are failing to consider that the respondent state is a developing nation, and hence, based on these two factors, the available resources and the steps that the state is already taking, noting the fact that it has ratified the Maputo Protocol, the International Covenant on Economic, Social and Cultural Rights, and even in itself, the Convention on Elimination of all forms of discrimination against women, is a step in itself, and hence, those are our rebuttals. Thank you.
Thank you very much. Baby, that marks the end of the moot. And thank you very much, counsels, for both sides.
Much obliged, Your Honor. The court will adjourn to complete the scoring sheets and prepare comments for the parties involved. We return shortly for the feedback session, where the judges will provide informal comments to the competitors on their style and structure only. Thank you for your cooperation. All rise.
Let me take this opportunity to welcome you back to the court, this session of the court. And I want to thank my co-judges. And no? The what? Are the teams in? The other teams? They are. Okay, thank you very much. May I now call on the Honorable Justice Olanike Adelukon to make her comments and.
Congratulations to Team 2415 and Team 2401. You all did well. You did so well for the manner in which you present, your ability to answer questions. You did so well, and I must really congratulate you. I must congratulate your coaches and your institutions. This is a very good reflection of a sound legal education. So I guess I'm giving you a clap. I'll just talk about one or two things on how you can improve on certain skills. I love the fact that when we ask you questions, we're actually not trying to steal your time, but it's just to test some things, especially your ability to think on the spot, your ability to remain composed, and your ability to be able to pick up immediately where you left off from. So it's not just to say, oh, we are being wicked or something. It's just like to assess some things in terms of the skills. We know you have the content. We just want to see how the skills play out to balance the content. And you did so well. So I'll just say, Pello, I love the way you actually maintain eye contact with us, trying to connect with us to see that, oh, are they actually following me? That is a good one. You should keep it up. And I like the fact that at the points, maybe you didn't have the direct answers to questions, but you're able to at least find a way around it and link it to your facts. So I'll just advise, maybe I should talk about Gautier too, Gautier. So I think you have to you are very assertive, I like that, but you lost your composure at a point. I guess maybe the question destabilized you, were not expecting it that early. But I love the fact that at a point you were able to bring yourself back on board. But generally for this team, I think when you're answering questions, a very strong point will always be to link it to authorities, especially precedents. So your ability to bring precedents to substantiate your answer matters a lot. It shows that you have a very good understanding of the law and the facts. Thank you. And for Naomi and Anthony, you also did very well. I also like your confidence level. You were also able to maintain eye contact with us, which is very, very important. And you were also assertive. So, and particularly for Anthony, I love your creativity. And that is very, very good. And so the ability to be creative around your issues. And yes, I think you can also continue to build on these skills. And I think that is the most important thing, and that is one of the things we need in these competitions, your ability to think on the spot and be able to solve social issues. So I'll say congratulations to the two teams. Thank you.
Thank you very much, Judge Olanike. May I call upon Justice Olayinka Adeneye? Thank you very much. I think I'm quite encouraged by what I see today. There is future for the legal profession, and especially for the rights of women in Africa, despite all the faultcomings or the little flaws that we see, or that we can point out from the provisions of the Maputo Protocol and the reality. So well done to the two teams. I would, without wasting time, like to adopt what the comments that Justice Olanike Adelakun has given. Thank you very much. Keep it up. Thank you very much, Judge Olayinka. Let me take this opportunity as president of the court to adopt the sentiments of the two learned judges, but also add that Africa is in good hands. I'm very, very encouraged by what I'm seeing and the fact that Kid Caller, you are so passionate about women not being demeaned. I think your sense, all of you, by the way, your feminist sense, the fact that you can defend the rights of women with such passion and with such knowledge and with such injecting hope in our African what would I say, appreciation of the rights of women. I'm very proud of you. I'm proud of how you have presented yourselves in terms of attire, in terms of addressing the court. Although as we grow, you will improve on most of all those aspects. But the future of Africa is in good hands. And I really want to appreciate you and encourage you and say we are proud of you. Thank you very much.
All rise.
All rise. The court is now in session in the case of Life Givers Watch International and the state of Kando. The presiding judge in this hearing is Justice Nancy Barasa, sitting alongside Justice Olainka Adeniyi and Justice Olanike Adelakun.
May I call upon the applicants to give us their appearances?
Most obliged, President Judge. Members of the bench, good afternoon. May it please the court, my name is Dixon Gitonga, lead counsel for the applicant, the Life Givers Watch International. Appearing alongside me is my learned co-counsel, Miss Edna Mweti, second counsel for the applicant.
Down the respondent side, please give us this one.
With the greatest respect to this magnificent temple of justice, E.F. Yakubu, I am not unaccompanied in my sojourn for justice before this court, as I am accompanied by my learned friend and co-counsel, A.O. Odion. Our humble appearances for the respondents in this suit. We are most grateful, Your Excellencies.
Counsels for the applicants, you may you will each have 30 minutes. Decide 30 minutes, but if in the course of your presentations you think you require some extra time, you may request. And if we grant whichever side, the other side will be entitled to equal time. You may start with your case, counsel for applicants. Thank you very much.
Much obliged, President Judge. If it pleases the court, we will take the next 30 minutes to present our arguments, and we will apportion our time as follows. I will use the first 15 minutes to address this court on the preliminary issues of jurisdiction and admissibility, as well as the first and second substantive issues. My co-counsel will thereafter take the subsequent 13 minutes to present our arguments on the third and fourth substantive issues, as well as the prayers we seek before this court. We shall respectfully reserve the remaining 2 minutes for rebuttals. Unless this court seeks any further clarifications, I will proceed.
Please go ahead.
Madam President, members of the bench, the matter before this court today relates to a grave violation of human and specifically women's rights. The voices of the women and girls of Nkandu have been silenced
by the weight of patriarchal oppression. This has resulted in the violation of the rights to health, reproductive autonomy, as well as a flagrant violation of the principle of the best interest of the child. We approach you today, first, to demonstrate that these violations did indeed occur, and to pray that this court redresses the same by granting the remedies sought by the applicant on behalf of surrogate D. Against this background, I will adopt the following structure in making my submissions. First, I will demonstrate to you that this court has the requisite jurisdiction to entertain this application. I will then proceed to show you that all 4 issues presented for determination are admissible before this court. On the first substantive issue, we will submit that the withdrawal of the declaration pursuant to Article 34(6) of the protocol is invalid and a violation of the African Charter. Lastly, on the second substantive issue, it will be a submission before this court that the actions of Nkandu are discriminatory against women on the basis of gender. My concluding remarks, honorable judges, will revolve around the imperativeness of upholding the rights of women and girls in Nkandu and Africa at large. Allow me now to indulge this court on the first preliminary issue of jurisdiction. On this, the applicant submits that this court has the jurisdiction to entertain the merits of this application. We draw authority from Rule 49(1) of the Rules of the Court, which mandate this court to conduct a preliminary examination of its jurisdiction for all applications that come before it. This court has also established in Lohi Issa Konate versus Burkina Faso, application 4 of 2013, that it must establish itself along 4 parameters of jurisdiction, namely material, personal, temporal, and territorial jurisdiction. As I will demonstrate before you, all 4 parameters have been satisfied. On material jurisdiction, Your Excellencies, this court draws jurisdiction from Article 3, Sub-Article 1 of the protocol establishing this court on all matters that pertain the interpretation and application of the Charter, the protocol, and other relevant human rights instruments ratified by the respondent state. In the instant application, Your Excellencies, as you will note from paragraph 57 of the fact pattern, the matters call for the interpretation and application of the Charter, the Maputo Protocol, the Courts Protocol, and other relevant instruments that Nkandu has ratified pursuant to paragraph 6 of the facts. Specifically, this court has held in Umuhoza versus Rwanda that it has material jurisdiction to entertain matters relating to the withdrawal of a declaration. Therefore, it is a submission that this element is satisfied. Proceeding to personal jurisdiction, we draw authority from Article 5, Sub-Article 3 of the protocol, which grants NGOs direct access before this court if 2 conditions are satisfied. First, the respondent state must have made the optional declaration of acceptance of jurisdiction pursuant to Article 34(6) of the protocol. And secondly, the NGO must have observer status before the African Commission. On the first element, Your Excellencies, it will be seen from paragraph 7 of the facts that Nkandu deposited its optional declaration in 2018, although it subsequently withdrew it in 2024. Be that as it may, Your Excellencies, we maintain that this court has personal jurisdiction since, as you held in Umuhoza versus Rwanda, the withdrawal of a declaration has no retroactive effect and therefore has no implication on cases that were filed prior to the deposit of the withdrawal, such as the instant application. On the second element, it is clear from paragraph 57 of the facts that LWI has observer status before the Commission. Since both elements are satisfied, this court will have personal jurisdiction. On temporal jurisdiction, Your Excellencies, with regards to time, the relevant dates are the dates of ratification of treaties, and we refer you to Annex B of the fact pattern, as read alongside paragraph 6, where it shows that all violations occurred after the relevant dates of ratification. Finally, Your Excellencies, on territorial jurisdiction, it is not in dispute that all the violations occurred in Nkandu, and therefore this court is conferred territorial jurisdiction. Having established all 4 tenets of jurisdiction, it is a submission before you, and we urge you to find that this court indeed has the jurisdiction to entertain the merits of this case. Your Excellencies, allow me to now turn your attention to the second preliminary issue of admissibility. The applicants submit that all 4 issues presented for determination are admissible before this court. We are guided by Article 6.2 of the protocol, which requires this court to rule on admissibility of cases if they satisfy the conditions of admissibility under Article 56 of the African Charter. Although Article 56 provides for 7 admissibility conditions, Council will only make submissions on the requirement to exhaust local remedies, and this is in preemption of the respondents' arguments. On this, our position from the very outset, Your Excellencies, is that we indeed acknowledge that we have not exhausted local remedies, as we have not exhausted the chains of appeal, but for good reasons. We will advance our arguments on 2 fronts. First, that local remedies have been unduly prolonged, and secondly, that they simply do not exist in the issue concerning the withdrawal of the declaration. On the first limb of argument, Your Excellencies, the Charter provides an exception to the rule of exhaustion of local remedies if it is clear that the procedure has been unduly prolonged. Although the court has no specific threshold for undue prolongation, it has established, or the African Commission has established, in Zimbabwe Human Rights Forum versus Zimbabwe, that it must apply itself to the specific nature and circumstances of the case and apply the common law doctrine of a reasonable man's test. Drawing your attention to the instant application, Your Excellencies, the specific nature and circumstances herein are that Surrogate D is critically ill. Her life hangs precariously in the balance. This is clear from paragraph 51 of the facts, where she's scheduled for an emergency hysterectomy surgery to remove her womb. Additionally, the children are extremely young and require immediate realization of rights. Taking these factors into account, and seeing as the Supreme Court has scheduled this matter for hearing on the 12th of March 2025, 1 year and 3 months away, our humble position is that this would have irreparable damage on the health of Surrogate D and on the lives of the children. For that reason, we ask you to find that this constitutes undue prolongation on the part of the state and find that those matters are admissible.
Counsel, considering the fact that the timeline of cases in the respondent state is has a kind of lifespan that is between that period, and the fact that the respondent had actually taken steps to accelerate this case, do you think this is still undue prolongation of the case, or would you not say that at least the respondent is taking steps to make sure the case is heard as adjourned?
Most obliged, Your Excellency. We indeed note the efforts of the state to schedule the matters as a matter of priority. However, we maintain that this is not any other case. This is a case of an emergency medical situation, and therefore 1 year and 3 months does not suffice. We additionally rely on the decision of the court in Majuru versus Zimbabwe, where it established 6 months as the reasonable time for hearing an ordinary case, let alone a case of emergency medical services. If that suffices as the nature of response sought by Your Excellency, I'll now proceed to the second element regarding the withdrawal of the declaration. Our position is that no local remedies exist in Nkandu that can remedy this violation, since it is a matter of international law and can only be heard by this court pursuant to Article 3.1 of the protocol. Therefore, as there were no remedies for the applicant to exhaust, we ask you to find that all issues are admissible. Having dispensed with the preliminary issues, allow me to now turn your attention to the first substantive issue. Our position, Your Excellencies, is that the withdrawal of the declaration is a violation of the African Charter. Madam President, members of the bench, Article 34(6) of the protocol is the gateway to this court. It provides an aggrieved applicant an avenue to access effective remedies and justice for their violations. It then follows that once a state has deposited this declaration, this grants the applicants subjective rights, such as effective remedies and access to justice, such that an arbitrary withdrawal would violate on these rights. This was the position of this court in Umuhoza versus Rwanda, application 3 of 2014, at paragraph 69 of the judgment. Your Excellencies, drawing your attention to the instant application, paragraph 58 will show that the respondent state withdrew the declaration for the sole purpose of reacting and protesting to the instant application before this court, barely a month after we filed it. Your Excellencies, we submit that this has two implications. First, it is in bad faith and violates the principle of good faith espoused by the Vienna Convention on the Law of Treaties at Article 26. But more importantly, Your Excellencies, it constitutes a regression of rights since the applicants already enjoyed these rights previously, and therefore the state is taking step backwards in the realization of rights. This is prohibited by Article 2(1) of the International Covenant on Economic, Social, and Cultural Rights. Allow me to also cite the scholarly writings.
Counsel, are you now challenging a state sovereignty to act or not to act? So if you are saying the withdrawal of the deposit of the declaration is arbitrary and the state does not have the right to do that, is that not like tampering on the sovereignty of the state?
Very well, Your Excellency. Our position is not that a state cannot withdraw. We in fact acknowledge state sovereignty to withdraw from a declaration since it is optional. The applicant is not intrinsically opposed to the withdrawal, but the manner in which the withdrawal was conducted. A keen reading of paragraph 38 of your ruling in Umuhoza, as I will read verbatim, Your Excellencies, that states are not allowed to withdraw at any moment or in any manner, as this would infringe on rights which require judicial security and certainty. Proceeding with my arguments, Your Excellencies, and having drawn your attention to those particular facts, we ask you to find that the withdrawal is a violation of the African Charter and to remedy the same, Your Excellencies. Allow me at this point to now proceed to the second substantive issue, which is at the heart of the applicant's submissions. Your Excellencies, our position is that the actions of Nkandu are discriminatory against women on the basis of gender. Members of the bench, it is an undisputable fact that discrimination against women is prohibited. We make specific reference to Articles 2 of the African Charter, as well as Article 2 of the Maputo Protocol. In Bob Chachawangwe versus Tanzania, this court has established two complementary elements that constitute discrimination: one, differential treatment, and two, interference of rights guaranteed in the African Charter. As I will demonstrate before you, both elements are present in this particular case, and this constituted discrimination. Allow me to refer this court to paragraph 11 of the fact pattern, where the Surrogacy Act 2017 treats men and women differently by automatically listing the surrogate mother as the mother of the child at birth, while the husband can rebut parentage. Your Excellencies, women and men are equal parties in a marriage pursuant to Article 6 of the Maputo Protocol. This is differential treatment, and although the respondent might argue that it is justified, our position, as I will illustrate before you, is that the result is a violation of human rights. As a consequence, Your Excellencies, after the surrogacy arrangement, most obliged, I see that my time allocation has lapsed. If this court would be gracious enough to allocate me an additional 2 minutes to round up my arguments.
Please go ahead.
Most obliged. Most obliged, President Judge. In summary, Your Excellencies, and reverting to my arguments, after the surrogacy arrangement, surrogate D was left to take care of the children on her own, despite Manza taking all the corresponding monetary benefits from the surrogacy arrangement. Your Excellencies, this is a particularly egregious violation because it treats the husband of the surrogate mother as the sole decision maker while she bears the consequences and the brunt of the surrogacy arrangement.
But Council, what's wrong with that? This is Africa. This is Africa. Men make decisions for women.
Most obliged, President Judge. We indeed acknowledge that the right to culture is guaranteed. However, in quoting the sentiments of Dr. Olanike in the preliminary hearings of this competition, culture is not static, it is progressive, and it must not infringe on rights. In this case, Your Excellencies, our position is that this infringed on the rights to dignity, security of the person, and more importantly, Your Excellencies, on the right to health of surrogate D. This is not acceptable in any regard, and this cannot be differential treatment. It is discrimination. It is rooted in male chauvinism and patriarchal conservatism. In conclusion, Your Excellencies, and as you retire to make your judgment, we invite you to grant the women and girls of Nkandu their dream of gender equality, which has persisted through the ages. For those reasons, we ask you to find that the actions of Nkandu are discriminatory against women on the basis of gender. I have now come to the conclusion of my arguments. If this court seeks no further clarification, I will respectfully yield the floor to my co-counsel to make further submissions.
Thank you very much. Please go ahead. Are you the one not feeling well?
Yes, but I will be able to stand.
But if you want to sit down, it will be okay with the court.
It's okay. Thank you so much, Presiding Judge. President Judge, Your Excellencies, good afternoon. And may it please this court, as earlier on introduced, my name is Mweti Edna, second counsel appearing for the applicant. I will take the next 13 minutes of this court's time to address it on the third and fourth substantive issue before this court, and lastly, state our prayers. With the court's permission, I will proceed to my submissions. Honorable members of the bench, the violations against surrogate D do not end with lead counsel's submissions. They continue to persist. We stand before you today to demonstrate the disregard of the Republic of Nkandu of its obligation to protect women's rights. This has led to the violation of rights of women and girls in the Republic of Nkandu and consequently undermined the present and future well-being of children born through surrogacy arrangements. Your Excellencies, against this backdrop, the applicants will structure their arguments with regards to the third substantive issue in 3 limbs. First, we will demonstrate that the Republic of Nkandu has violated surrogate D's right to health by denying her medical services on a discriminatory basis. Then, we will proceed to illustrate that the Republic of Nkandu has violated surrogate D's right to reproductive autonomy by denying her a chance to choose whether to have children and the number of children to have. And lastly, Your Excellency, we will show that the Republic of Nkandu has disregarded the principle of the best interest of the child by failing to hold GISA accountable for the sale of children. I'll now turn the court's attention to my first limb of argument regarding the violation of the right to health of surrogate D by the Republic of Nkandu. Your Excellencies, Article 16 of the African Charter provides for the right to the highest attainable standard of mental and physical health. States then have to ensure that they meet the tripartite typology of obligations set forth by the case of Serak versus Nigeria, 2001 at paragraph 57, which obligates states to respect, protect, and fulfill its citizens' rights. In the present case, Your Excellency, the Republic of Nkandu has violated surrogate D's right to health by failing to protect and respect her right to health. While the respondents might argue that this right is subject to progressive realization, the Committee on Economic, Social and Cultural Rights, General Comment 14 on the right to the highest attainable standard of health provides for the minimum core obligations with regards to the right to health. Particularly, Your Excellencies, states should provide medical services on a non-discriminatory basis to marginalized and vulnerable people in society. In the present case, and with a reading of paragraph 43 and 45, it will be seen that surrogate D could not get medical services in government hospitals. Additionally, and if I may turn your attention to paragraph 50 of the fact pattern, surrogate D could not get medical services in not one, but all hospitals in Tanam City. Your Excellency, the major excuse being that complications arising from surrogacy arrangements cannot be treated at the government's expense. This, Your Excellencies, was discrimination based on her reproductive choices, and it consequently led to the loss of her womb that will be seen in paragraph 51 of the fact pattern. Paragraph 47 of the same general comment states that under no circumstances can the state justify non-compliance with the minimum core obligations. Hence, we ask you to find that the Republic of Mkandu violated surrogate D's right to health by denying her medical services on a discriminatory basis. I will now turn your attention to my second limb of argument regarding the violation of the right to reproductive autonomy and the right to the special protection of women. Your Excellencies, women's right to health is not merely a privilege. It is a fundamental aspect of human dignity. The applicants acknowledge that the violation of the right to dignity and reproductive autonomy has not necessarily been effected by the Republic of Mkandu. However, Your Excellencies, if states allow private actors to act freely and with impunity, it will be a violation of their due diligence obligation. The case of Velasquez Rodriguez versus the state of Honduras, 1998 at paragraph 176, provides that states owe a duty of due diligence to its citizens. What then are non-state actors, Your Excellencies? These are individuals or organizations that do not act on the states or by the state's organs. This was espoused by the case of Zimbabwe NGO Forum versus Zimbabwe at paragraph 136. Hence, states have an obligation to prevent human rights violations, investigate the said violations, and hold the perpetrators to account. The Republic of Mkandu failed to do so by violating surrogate D's right to reproductive autonomy.
Answer. Would you say the respondent did not act when the media brought this alleged violation to the attention of the state, and the state conducted an investigation and also had to act in the interest of balancing the contractual rights of parties and protection of rights? Would you say the state did not act? The state actually investigated, right?
Most obliged, Your Excellency. Indeed, the state conducted investigations. However, a reading of paragraph 26 of the fact pattern will show that Mansa disclosed that both of them were illiterate and could neither read nor understand. This shows that surrogate D did not understand the contract and the consequences it would have on her life. This was a violation of her right to reproductive autonomy, since she did not give her fully and informed consent to the contract regarding surrogacy. What then is fully informed consent, Your Excellencies? In the case of AS versus Hungary, the CEDAW committee describes it as giving information in an understandable manner to enable women exercise their reproductive rights. We ask you to find that the Republic of Mkandu violated this principle and violated the right to reproductive autonomy. Seeing that my time is well spent, I will I will handle in summary the right to special protection provided for under Article 24 of the Maputo Protocol. Your Excellencies, a reading of paragraph 2 of the fact pattern will show that Surrogate D comes from a marginalized community. She is also a widow. The Republic of Mkandu ought to offer special protection to her and other women living in Talaka district. The lack of a legal framework that provides for the contracts with regards to commercial surrogacy has led to the violation of women's rights. Your Excellency, paragraph 20 of the fact pattern will show that 85% of surrogate mothers hail from Talaka district, which is a poor and marginalized district. This has led to the exploitation of women since they do not understand their rights and cannot give effect to them. Additionally, Your Excellency, paragraph 23 shows that NGOs said that the Republic of Mkandu, in enacting the Surrogacy Act, was not alive to the consequences and the rights of women in the Republic of Mkandu. It was only a means of generating income. This violates the right to special protection, and we ask you to find that the Republic of Mkandu violated this principle. I will now turn to the third limb of argument regarding the violation of the principle of the best interest. Article 4 of the African Charter on the rights and welfare of the child provides for the principle of the best interest of the child. The case of Legal Rights Center versus Tanzania by the African Committee on the Rights of Children states that in actions by private and public actors, the principle of the best interest of the child should be accorded paramountcy. The Republic of Mkandu violated this principle by failing to hold GISA accountable for the sale of children prohibited under Article 29 of the African Charter on the Rights and Welfare of the Child. The optional protocol to the CRC on the sale of children describes sale of children as any transaction where a person or a group of persons transfers a child in exchange for remuneration. This, Your Excellency, gives rise to three elements, which are payment, transfer, and exchange. This have been satisfactorily met since a reading of paragraph 35 of the fact pattern will show that Mansa received $1.5 million immediately Surrogate D gave birth to the children. Additionally, paragraph 36 of the fact pattern will show that Surrogate D, in exchange of giving parental rights, received a deposit of $1 million. We ask you to find that the Republic of Mkandu disregarded this principle by failing to hold GISA accountable for the sale of children. I will now turn your attention to the fourth substantive issue regarding the reparations we seek. Your Excellencies, Article 27(1) of this court's protocol mandates the court to grant reparations if a violation of human rights has been established. In the case of Kenyatta versus Burkina Faso, application 4 of 2013, the Commission provided that the standard of proof for reparation is based on a preponderance of evidence. Lead counsel has established that the Republic of Mkandu has violated the right to discrimination of Surrogate D. Seeing my time is quickly running out, I would ask for a discretionary 1 minute to sum up my submissions.
You are granted a 1 minute request.
Most grateful, Presiding Judge. Since lead counsel has established the violation of the right to non-discrimination and that the Republic of Mkandu has violated Surrogate D's right to health and reproductive autonomy, as well as the principle of the best interest of the child, we ask this court to find that the Republic of Mkandu owes Surrogate D reparations and grant the following reparations. First, that the Republic rehabilitate Surrogate D and other surrogate mothers for the moral and psychological harm caused by the violation of their rights. That it compensates Surrogate D for the violation of the right to health and reproductive autonomy. And lastly, Your Excellency, that this court recommend to the Republic of Mkandu to put in place measures to enable assisted reproduction to continue in the Republic of Mkandu. Your Excellencies, as you retire to make your decisions, we ask you to note that the issues before us are not merely legal conundrums. They are deeply human stories that require our commitment and our unwavering commitment to justice, and grant the prayers sought by the applicants in their written submissions. The applicants rest their case.
Thank you very much. Counsel for respondents, you will be entitled to the extra minute that was granted to decide. Thank you very much. Go ahead.
Thank you very much for your good graces, Your Excellencies. Your Excellencies, as earlier stated, I am E.F. Yakubu. I am the lead counsel for the respondent. Your Excellencies, with regards to time, I will be using a period of 13 minutes for my argument, that is the first and second issue, while my learned friend here, A.O. Odion, will be using the period of 12 minutes for our arguments on the third and fourth issue, as well as our conclusions and prayers sought. Your Excellencies, with regards to the first issue for determination, which is the jurisdiction and admissibility of this case. However, Your Excellencies, before I proceed to the substance of the jurisdiction and admissibility of this case, I would like to address something which is so fundamental and so sacrosanct, which the applicant has stated, which is the case of Ingabire versus Rwanda. It has been cited by the applicant 4 times, Your Excellencies. However, Your Excellencies, in considering the judgment of the courts in that particular case, it is important to consider the ratio decidendi, which is the reason for the decision. Your Excellencies, by virtue of paragraph 53 of Ingabire versus Rwanda, it can be seen, Your Excellencies, that the respondents did not contend the argument of the applicant with regards to the application of the VCLT. It is stated in paragraph 53 that the respondents did not contend the application of the VCLT in that case. However, Your Excellencies, apart from that, it can be seen by virtue of paragraph 54 of the judgment in the case of Ingabire versus Rwanda that the court applied the VCLT only by analogy. And now it is important to distinguish the judgment and the decision in that particular case, the reason for it and the peculiar circumstances of that case, from the peculiar circumstances in this particular case. Your Excellencies, it can be seen, and it is crystal clear from the judgment in that particular case, that the court only applied the VCLT by analogy because the Republic of Rwanda had signed the VCLT. Your Excellencies, the importance, the purpose of signing the VCLT is to show that you recognize the principles stated in such treaty. However, in this particular case, the respondent, which is the Republic of Mkandu, has not signed nor ratified this particular treaty. Your Excellencies, it's also important to consider the separate opinion of Judge Fatsa, where she stated in that particular case, Your Excellencies, that the court has caused a bit of confusion with regards to the applicability of the VCLT in certain instances. Your Excellencies, there are certain provisions of the VCLT that do not apply as customary international law, such as Article 56, because they do not follow the concept of state practice and opinion juris. Your Excellencies, this has been stated in the case of Basikovo Nigamaro's case, which is Hungary versus Slovakia, that Article 56 do not apply as customary international law. And Judge Fatsa stated in that particular case that the court has caused a bit of confusion in its application of the VCLT in cases where it does not apply. Your Excellencies, now having distinguished between the case of Ingabire versus Rwanda and the case at hand, and while the court should not apply the VCLT, I will now proceed to the jurisdiction and admissibility of this case. Your Excellencies, with regards to jurisdiction and admissibility go hand in hand and are two sides of the same coin, effectively leading to the determination of a suit or lack of it thereof. Your Excellencies, in Rule 49 sub 1 of this court rule, as well as the case of Kambole versus Tanzania and Mariam Kuma and another versus Mali, this same court has reiterated the principle, Your Excellencies, that the court is to determine that it has jurisdiction on 4 criteria, which is the material, temporal, territorial, and personal jurisdiction. Your Excellencies, while we concur that this court may have material jurisdiction, this court may possess the requisite temporal and territorial jurisdiction, it is our humble and considered submission in this particular case that this court lacks the personal jurisdiction to adjudicate on this matter. Your Excellencies, before a court can be vested with personal jurisdiction, the respondent state, which is Nkandu in this particular case, must have ratified the protocol and deposited the optional declaration under Article 34(6). However, Your Excellencies, it can be seen in this particular case, by virtue of paragraph 58 of the compromise, that the Republic of Nkandu has withdrawn its declaration under Article 34(6), thereby nullifying any prior consent that subjects it to the jurisdiction of this court. Your Excellencies, our postulation... Yes, Excellency.
Are you now insinuating that we should rob the applicant of its standing before the court on a retrospective application of your withdrawal?
Thank you very much, Your Excellency, for that beautiful question. However, I would like to draw the attention of this court to something which is so pivotal and so sacrosanct, which is with regards to the fact that while it is true, it might appear that that it would be a form of retrospective jurisdiction. However, when we consider together the concept of unilateral acts, the position of the protocol as a treaty, and how the declaration is separable from the protocol, as stated in the case of Ingabire versus Rwanda, it is a unilateral act. And by virtue of Article 10 of ARISWA, by the case of Congo versus Rwanda decided by this same court, a unilateral act can be withdrawn unilaterally in cases where there are not procedures stipulating the kind or the procedure for its withdrawal. And that is exactly what has happened in this particular case. There are no procedural rules. The VCLT does not apply. The VCLT does not apply even as customary international law. And there is no particular laid down principle with regards to withdrawing this particular declaration as a unilateral act. And the respondent has withdrawn it in this particular case. Your Excellencies, I would like to draw the attention of this court to something which is also so pivotal and so sacrosanct, which is the concept of sovereignty. Your Excellencies, in African Commission on Human and People's Rights versus Kenya, this same court reiterated the principle that sovereignty is of paramount consideration, and it is at the discretion of the state to regulate the scope of its international obligations and also to withdraw from such obligations where it is necessary. Your Excellencies, in that particular case, it was also stated that state consent is sine qua non to the jurisdiction of this court, and such consent can be validly withdrawn. Your Excellencies, this same principle is reiterated in the case of Mudua versus Tanzania, where this same court reiterated the principle that state consent is central to the jurisdiction of this court, and any withdrawal of such consent must be respected and recognized. Your Excellencies, allowing the applicant's case to proceed would undermine the sovereignty of the Republic of Nkandu, which is provided under Article 27(1) of the African Charter on Human and People's Rights, which gives states the discretion to regulate their internal and external affairs without undue interference. Your Excellencies, the applicant
Counsel, are there any circumstances in which sovereignty claim can be challenged, in your learned view?
Definitely, Your Excellencies. Of course, to every rule, there is an exception. And in cases where, for example, the state has given consent, for example, the optional declaration where you have given consent to the court to exercise jurisdiction, in such particular case, there is a limitation to your sovereignty. And in cases where it involves certain, for example, with regards to the doctrine of necessity, where it is necessary to ensure compliance with international law, the sovereignty of a particular country might be limited. However, none of those exceptions, none of those principles are applicable in this particular case. Your Excellencies, with regards to the admissibility of this case, I would like to draw the attention of this court to Article 6(2) of this court rules, which provides that this court is to rule in line with, is to rule on the admissibility of the case in line with Article 56 of the African Charter. And Your Excellencies, Article 56 of the African Charter relates to the exhaustion of local remedies. That is, Your Excellencies, local remedies must be thoroughly exhausted unless they are unduly delayed or prolonged. Your Excellencies, the respondent stated something which is important to address, which is the fact that the municipal courts of Nkandu cannot really provide the remedies necessary. That it is at the discretion, it is something, it's a concept that should be left to international, which is a concept of international law, that should be left to international courts. However, Your Excellencies, surrogacy is not the exclusive preserve of international courts, as it can be decided upon by municipal courts, and the applicant is obligated to exhaust local remedies to the apex court, Your Excellencies. Your Excellencies, the exhaustion of local remedies has been reiterated in the case of Sagone versus Tanzania and Rule 50 sub 5 of this court rules. Your Excellencies, it can be seen by applying the aforementioned provisions, statutory and judicial, to the facts of this case, that by virtue of paragraph 53 of the compromise, the Supreme Court of the Republic of Nkandou has stated that this particular case will be heard on the 12th March 2025. Your Excellencies, however, by virtue of paragraph 57 of the compromise, it can be seen that the applicant jumped the gun by instituting this action on the 29th of January 2024, thereby precluding the domestic courts the opportunity to address the alleged violations. Your Excellencies, the importance and purport of the exhaustion of local remedies cannot be swept under the carpet. This is because the importance of the exhaustion of local remedies is to ensure, Your Excellencies, that state sovereignty is maintained and this particular court does not become a court of first instance. Your Excellencies.
Counsel, are you now saying there are no instances where the exhaustion of our local remedies will be set aside?
Thank you very much, Your Excellency. Yes, of course, like I stated earlier, to every rule there is an exception, and of course the exception is undue delay or prolongment. However, Your Excellency, in this particular case, by a combined reading of paragraph 5 of the compromise and paragraph 42 as well as 53 of the compromise, it can be seen, Your Excellencies, it can be seen and it is crystal clear, Your Excellencies, that on a normal day, the Supreme Court of Nkandou takes the period of 5 years to adjudicate on a case. However, in this particular case, it is slated for 1 year and 3 months. And the Chief Justice even had an interview where he stated that cases of sensitive nature will be heard at an earlier date rather than just the normal date it has been set for, showing that the Republic of Nkandou cares about the sensitive nature of this case and local remedies were not in any way